great. Thank you for that introduction. Happy 2022, everyone. Glad to be with you today. Got a fun topic, and I'm probably going to hit on this a couple times throughout the next few months, and we'll explore some different angles on mechanisms for alternative dispute resolution. There's actually quite a few, and it's a broad topic. Hopefully you'll learn something today. It's also a topic that I'm very passionate about. Candidly, in my almost 20 years of law practice, I started my practice as primarily in litigation with a large law firm out west, and spent first couple of years litigating in big corporate type lawsuits representing banks and casinos and developers. Now our clientele is a little bit more diverse. A lot of my clients are smaller businesses. I'm often in contact with the person who's calling the shots, who's making a decision, really one of the founders or owners of a company oftentimes. And litigation is incredibly stressful. I tell folks all the time, and I tell clients who haven't had the experience of being involved in especially a protracted litigation, that there's multiple costs. There's not only the costs for attorneys and the expenses that you spend in the litigation. Of course, there's a monetary cost, but you also have to account for the emotional toll that it takes on parties and the folks that are involved, and the time commitment. That's probably the biggest shock that I see with a lot of clients, even in business disputes, is the amount of time that you can spend dealing with lawsuits. So even though I have spent my career, a good part of my career, especially in the early portion, working in litigation, I consider myself one of the worst salespeople of that type of practice, because I usually try to keep people out of it. So I'm going to go through today, and as you can see on the slide, I am a certified circuit mediator in Florida, also qualified for arbitrations with a number of organizations. And what I'm going to talk about today are mediations and arbitrations and other mechanisms that you can use to resolve disputes, either by having these provisions in contracts ahead of time, by engaging in early communication when disputes arise, or somewhere along the process. So you see on the screen here is an agenda of what we're going to cover today. Primarily three different categories of alternative dispute resolution. And so normally people think of a business dispute or a dispute even among spouses, or some neighbors, real estate, anything of that nature. You go to court and there's two sides, and you fight it out in court. And that's candidly, it's just a terrible way to resolve legal issues if you can avoid it. The first type of dispute resolution that we'll touch on here is two main categories: binding and non-binding. And what that means is, if for the non-attorneys who are joining us today, non-binding dispute resolution means that you take a shot, and if you don't get the issues resolved, then you have another option, and that option may be an escalated dispute resolution procedure, or it may be going to court. Binding is typically where you have a third party. The most common is in an arbitration. You have a binding arbitration, and that decision of the third party arbitrator or panel of arbitrators, or whoever's making that decision for you, could be experts that are predetermined. That's binding on the parties, and oftentimes if it's binding on the parties, then you can just take that decision of that third party, take it to court, and have it reduced to a judgment in a relatively simple process. So we're going to talk about different non-binding alternative dispute resolutions and then binding, and then we'll talk a little bit about what the differences are, key differences between the closest thing to litigation, which is really a binding arbitration, and litigation itself. And I'll explain why in my contracts that I'm drafting and a lot of the work that I do for clients, that I often include an arbitration provision, because we want to stay out of court. And there's some specific business purposes and reasons why we do that. So you see here, you have a copy of these slides. I don't need to read everything to you, but essentially the message here is that if you want to avoid a bad outcome in a lawsuit, then stay out of a lawsuit or get out of a lawsuit. And if you're contemplating being involved in a lawsuit, generally with my clients, I want to have a strategy for exiting. What's the goal, and how are we going to get out of this? And even better is if we can take the dispute that would be in a lawsuit and figure out some alternative mechanism for resolving the issue. Another, most common here in Florida, the process that we use outside the court is in mediations, and we'll talk about the advantages of mediation as well. Here's a little chart, kind of breaks this all down for you. Your non-binding is generally without third-party intervention, a neutral, a mediator, or some other person hearing the dispute. This is just the parties trying to work out their problems without going to court and without going through a formal process. And this is just your regular negotiation. This doesn't have to be a fully informal process. I have drafted contract provisions myself and seen contracts that have language that requires the parties to negotiate. And there's one provision that I draft sometimes that if the parties agree to it, or if my client agrees to it, that may require at least one, not just a letter writing campaign or emails, but one face-to-face negotiation, or one in person. We used in person a lot more before the pandemic, but now we will say face-to-face. You'll have a video conference, or my preference still on resolving problems is usually to be in the same room with the other folks if we can do it. Several different types of non-binding resolution processes that involve third-party intervention are listed here. Everything from non-binding arbitration, which is distinct from binding arbitration, to mediation, peer review panels, which are common in medical, and so forth. So we'll talk about each of these a little bit along the way. And then finally, your binding processes. This is where a decision is made, and once the decision is made, it's essentially final, with a few exceptions. The biggest exception probably is going to be if there's a lack of clarity, if there's inherent prejudice in the process or inherent unfairness. That's tough to prove, but it's oftentimes going to be a jurisdictional issue. So arbitrations are generally going to be enforceable because if the parties agree to an arbitration, they have contractually agreed under the Federal Arbitration Act and various state laws, including arbitration laws that are adopted in Florida. Courts are going to enforce that unless the parties did not agree. If somebody didn't sign the contract, then it calls into question the jurisdiction of the arbitrator to make that decision. In some environments, such as FINRA, and you noted there in the beginning, I'm qualified as a FINRA arbitrator. Your contracts there and a lot of the processes, the disputes that arise, are always going to be subject to arbitration in that FINRA system. And I can't see the questions today, so if there's questions, I'm sure that Tony or the folks will let me know, but if you have questions, feel free to pop those up. But as we jump in here, again, the negotiation, most people understand what this is on a pretty basic level. And what I just want to point out here is, some of the advantages and disadvantages to each of these. In my experience, negotiation, the problem here is that parties, when they're just negotiating with each other, unless they're really trying to reach a resolution, oftentimes there's an imbalance of bargaining position, and there's a lot of posturing that goes on. But I typically encourage negotiations whenever disputes arise as a first step, and sometimes you use that to get to a certain level, and then you use a mediation or some other process to push you over the hump. But this is going to be the most cost efficient generally for parties. It's going to be least costly. You're not paying a third party to be involved and help resolving the disputes. You don't need to be represented by counsel, although depending on the circumstances, you may very well want your counsel and other parties involved. And it's the most informal process. It's just folks trying to come to some type of agreement on some type of dispute that has arisen. Mediation is a more formal process here in Florida, where I practice primarily. Mediation is required in almost every case that goes to court, and if not every case. And I just say that I'm not aware of even any exceptions as far as civil cases go. Divorces, business cases, anytime a lawsuit gets filed, a court is going to refer the parties to mediation. And so mediation, even though it's a voluntary process, is often still court ordered. You still got to show up and engage the process. And the reason for that is that there's a high level of success, depending on what numbers you see and who's producing them. I don't know who keeps track of this, but we see numbers, somewhere in the area of 80% or more cases get resolved through mediation. On top of that, it's been my personal experience, very few cases that go to court, go to trial, and oftentimes a good, effective mediation can get the parties on the path to resolution. So I have a case right now that's pending in federal court. I'm trying not to do that very much anymore. Again, I'm trying to keep people out of court. But in that case, we had a mediation a couple months ago, and that got the parties very close to getting a resolution done. It's going to be finished. In a mediation, the process involves a third-party mediator or somebody who's neutral to the parties that brings the parties together and tries to work through a process where you identify the issues in dispute, and you explore different options to try and resolve those issues. Some mediators will take different approaches. They will try and facilitate some discussion, build trust with the parties, and facilitate communication back and forth between the parties to a dispute. The way that usually happens is that, and again, this is, probably a lot of the folks are familiar with this, but just quickly, if you're not, typically in a mediation, everybody meets in the same room, or if it's done virtually, everybody meets on the same screen. We used to always do these in person, and you'll have what's called a general session or an opening session where the parties may make opening statements. They may get to respond to one another. The mediator may ask questions, and the openings may be similar, maybe an abbreviated style of what you would hear in court, but it's an entirely confidential proceeding. And by making it confidential, it allows the parties to communicate without fear that what they say is going to be used against them later, but it allows for an open dialogue. And you have this initial joint session. Some mediators will take a more active approach in asking questions and challenging the parties. Some take a more laid back approach, and sometimes it just depends on the nature of what the dispute is. After that joint session, then the parties will break off into separate rooms that are called caucuses. And in these separate caucuses, the mediator will go back and forth. It could be two or more parties. It could be multiple. There may be several different parties involved in a dispute, and the mediator will go to the different rooms, talk to the parties individually, try to get a better understanding of their positions. Again, the mediator is trying to build trust with the parties at the same time, and facilitate communication, and maybe challenge folks on positions that are less realistic, to give them a better perspective on reaching some type of resolution. If parties are in a dispute and you go into a mediation or any other type of session, you can't expect to get everything that you want. And part of the job of the mediator is to bring some realistic perspective, at least in my view. It's to bring some realistic perspective to the dispute for each of the parties' benefit. The mediation is, we like to say that mediations, you control your own destiny. So in court, or if even in a binding arbitration, when you go through that process, somebody else, you're presenting your arguments to let's use the court as the example, because these are all alternatives to going to court. You present your arguments to the court or to a jury or judge, and now your decision making is in the hands of a third party. And sometimes those parties are limited. If you're arguing over rights to a deposit, for instance, in a real estate contract, oftentimes it's going to be an either-or scenario, where one side's going to win, one side's going to lose, and somebody's going to be very unhappy. There are oftentimes other considerations. Divorces are very well known for this, that you have, there are other things in consideration, or other issues in play other than just money and things where somebody can make a strict decision. It may be visitation rights. It may be, we see this a lot as well in business and partner disputes, maybe negotiating the scope of a non-compete in connection with a partner leaving a medical practice or some type of professional practice. The time for a buyout or a payout on a separation, on a business separation. These are things that have some flexibility to them, where a court won't necessarily be in a position to give you to be creative with the solution. and mediations allow for more creativity with solutions. Essentially, as long as the parties don't agree to something that's illegal, you can craft a solution that has that's binding on the parties and brings some satisfaction sometimes to the parties that the court that's just not available in court. Another very common example of this is an apology letter. And I've been involved in cases where somebody wants an apology letter, or somebody wants a retraction for something that was said, some type of defamatory or negative statement, and they want that statement corrected. A court is not going to order a party to write an apology letter to somebody else, but in a mediation, a party can agree to that, and it may have some bargaining value. And timing for mediations, this can be very early in a process. It can be after a case is well developed, so you can have something start in litigation and then the parties are referred to mediation. We can go to mediation before a lawsuit's filed. That's often my preference, and a lot of the contracts, if I draft contracts for my clients, that's usually what I will recommend. For instance, like in a shareholder agreement or an operating agreement, if there's a dispute, I may have a provision that requires the parties to engage in some type of negotiation and or mediation before filing any type of formal action. Get the parties to try and resolve disputes before you file the lawsuit. You can have a situation where a lawsuit gets filed and then the parties go to mediation early before they spend a lot of time and money in litigation. And then there's other circumstances where you really need more information in order for a case to be able to get resolved. If it's something that's going to be factually intensive, where the parties have to exchange information, perhaps you're involved in a situation where there's the value of a business or the value of a particular asset is in play. And so you really need to get some professional opinions as to what that value is in order to have a realistic shot at getting a case resolved. So the parties can be flexible on the timing, but the general rule to me is to start making that evaluation at least early and see if you have an option or an opportunity to get something settled before you go to court. Remember, once you file an action in court, it is now public record, and other people can pull that up and look at your dirty laundry. And even if you are not litigious, but you do business with people who are, for whatever reason, I have been involved in situations with clients evaluating potential business opportunities, mergers, or business joint ventures, partnerships, and so forth, where it's very common, or bringing in new partners. You're going to bring in your law practice or medical practice or something else. You're going to bring somebody in, offer somebody an opportunity to join your practice, and you do a background check. And if you see that somebody's been involved in for a company, depending on the size, and this is all there's a little bit of it sort of depends, of course, on what the circumstances are. But if you see a party or an individual who's been involved in several lawsuits, whether the plaintiff or the defendant, you start to question that. Somebody who's been, one or two lawsuits, not uncommon. Somebody who's been involved in 6 lawsuits over the last 3 years, 5 years, you start to wonder why they keep running into these problems. Why do they keep ending up in court? And that will scare people off. And if you're a company and you're trying to bring in investors, or you want to grow, or you want to get the attention of private equity, or if you just want to have a good, good relationship from a client customer service standpoint with the public, you don't want to have somebody do a search and find 13 entries of your company in the court record being involved in various lawsuits with whether it's employees, competitors, who knows what, vendors. So again, all of these give you an opportunity to avoid that type of situation. Mediations are generally done in one session, but they can be longer. I've been in mediations that have run more than a day. I've been in mediations that have run, started in the morning and ran past midnight. I've been involved in some where the parties don't reach a settlement, but the parties come back over the next few days and continue the dialogue and get a case settled. And a couple times I've been involved in cases where the first mediation isn't successful, but at least the issues are narrowed and people understand what where the big disputes lie. They can go work through those issues, then come back, take a second crack at the mediation, and maybe with the same mediator or somebody different, and get the case resolved. And while I can't say that every mediation I've been involved with has settled, of course, every time I've been involved in a case where there's been 2 mediations, the second mediation has always been successful. So that's my own personal experience in that. So now let's move on and talk a little bit about this chart. I'm not going to go through the entire chart. I put this on here. I thought this was useful, but the process of mediation, how you get there, often it's going to be by an agreement of the parties, but it could be a court recommendation. And then you select the mediator. And the clients will often ask, is it hard to select the mediator? Should we go with the person the other side recommends? But really, in most circumstances, mediators are required to be neutral, and I've never had an issue with other attorneys trying to select a mediator. Sometimes we'll even ask for suggestions, depending on what the subject matter is, depending on the geography, depending on the relationship of the parties. Sometimes the attorneys actually have a good working relationship and understand that one of the clients, maybe our own client or the client on the other side, is going to be the toughest person to move, and we will focus our efforts on selecting a mediator on who's going to interact best with that particular client. So attorneys that have a good professional working relationship and work well with each other will have no issues generally selecting a mediator, and I've just never seen that be a problem. Then you essentially, after you select your mediator, there's some planning, just like strategy sessions that you'll be involved with to prepare for the mediation. There may be documents and other things that are necessary in order to make that process effective. You want to share some of that information with the mediator, sometimes in advance. If I get anything in advance, I want to take a look at that and potentially even talk to the parties in advance, ask questions to come in prepared to try and make the joint session as productive as possible. During the mediation session, I explained that a little bit for you guys, the opening and then the different caucusing sessions where we negotiate and then hopefully come to some type of resolution. And if there's not, maybe even narrow the issues, or at least bring the parties to some place where it helps facilitate a process to resolve their disputes going forward. And if that's not all successful, then maybe the next step in the ADR process or in court is what's required. So we often get asked, what cases are suitable for mediation? I'm not going to go through the entire list, but I put this in here for your benefit to just look at some of the examples where mediation could be particularly effective. And since most cases that get filed in court, now I think there's oftentimes cases that get resolved or disputes that get resolved without any filing in court. So when cases do get filed, the great majority of those settle without ever going to trial. So all of those cases essentially are appropriate for some type of dispute resolution mechanism, mediation being the most common of those. I did put bold here one of the bullets here in the slide is that where the parties have a desire for future relations, litigation can be nasty. Now people take very extreme positions, cross-examining a witness. Being a witness in a lawsuit, especially if you're a party witness or if you're one of the primary witnesses, it can be very tough, because the job of the attorney on the other side, one of the things the attorney is going to try to do in order to make their case look better is to try and hit into the credibility. I don't want to say attack, but that's really what it is: attack the credibility of witnesses, attack the credibility of parties, focus on statements, potentially out of context, maybe. Litigation can lead to a lot of hard feelings. And if you're in business, especially, and you want to have, potentially you want to do business with parties, going into the future, maybe even the party where a dispute has arisen, or you want to have the opportunity to do so, trying to resolve that problem through a mediation process can be very effective in enabling you to salvage the relationship going forward. All right, so that's a rundown on mediation. We'll come back a little bit and maybe look at a couple more issues there, but I want to talk about some of these other mechanisms as well. Mini trials, these are other versions of alternative dispute resolution that are not as commonly used. But in this type of situation, very early in a case, typically, or in a dispute, the parties will make a presentation to a neutral and representatives from both sides, so authority to settle the case. This is a non-binding process, but you get to hear facts, and you have the assistance of a neutral third party, an attorney or somebody in that position, who helps the folks work through their issues. It's similar to, it's like a hybrid a little bit. It has a little bit of the components of a mediation, a little bit of the components of a non-binding arbitration. The nice thing about this process is that it's private. It helps the parties identify issues, that identify potential weaknesses with their positions on each side, work towards a potential solution, and it's private. Again, you're keeping this out of the public record. Conciliation, you don't hear that term very often in Florida. It's used more in Florida and in certain business contexts. It's used a lot in the employment arena, and it's used in certain jurisdictions internationally. You hear that a little bit more. I have some clients that have done business in the UK and overseas, and we'll hear more about conciliation. That term comes up a lot in the employment context. And again, it's just another process where a third party is involved. A little bit different, as a mediator is facilitating communication, trying to get the parties to reach a settlement. In a conciliation, that neutral third party may be a little more active in trying to prod the parties, making some suggestions for the parties to settle. So it's a small distinction, but it's a different type of process, very similar to mediation. The next one here on the screen is peer review panel. This is very common in medical. Doctors will be on hospital staff, and that's where we see it, at least in my practice, where we see it most often. And if there's an allegation that the doctor violated the hospital bylaws or didn't follow procedures properly, there could be a peer review, panel review of the actions of that person. This is used a lot, again, in the employment context. It doesn't have to be doctors. It can be in other circumstances as well. Companies will sometimes set these up. Large companies will have an internal peer review panel. So you're not reliant simply on just dealing with one supervisor and a nameless, faceless HR department. If you have an issue with a supervisor, you can oftentimes bring that to the company's attention, and there'll be some process internally to resolve that, and to try and reach a resolution through a peer review panel, with the idea being that it's not just somebody over you making your decision, but it's a panel of peers, of other coworkers, all with the same goal in mind, and to creating a good work environment, who are helping to resolve disputes between the supervisors and the subordinates. I tossed this one in here because we're talking about different processes and mechanisms for dispute resolution. Candidly, I've never been involved in this. But stakeholder dialogue is a term that's used sometimes for real estate development and with environmental issues, where you're bringing together parties to try and resolve potentially current issues and future issues. So it's just another mechanism it's similar to a negotiation, but often involves a neutral third party who helps the parties identify the issues that they're going to face down the road and resolve them before they come up. Here's another process not used as often, but has some value, and it's used in certain types of cases. This early neutral evaluation. This may be very similar to a non-binding arbitration or a mediation or a hybrid of the two, where an independent person provides an opinion, reviews documents, may conduct some, their own investigation even, and essentially through a Q&A session, and then sometimes issue an opinion on what they think are the proper responses or some of the issues that need to be sorted out in a dispute. There are early procedures in the statutes that deal with resolution of condo association disputes, which makes sense because these are often folks who have to live together. So if there's a dispute between condominium owners who are all members of a condominium association by default when you own a condominium, and the board of directors or there's a dispute with the association in some fashion, then the condo statutes provide a mechanism for early arbitration or mediation before any court action is filed or within a short period of time after that action is filed. We also see that in medical malpractice cases that you have to go through an early review. That statute's been challenged, and I know right now there's a little bit of it's a little bit in flux, but there has traditionally been, and Florida is not uncommon for that. I know other states do the same thing, where there has to be some type of enhanced review or enhanced probable cause or a process that has to be followed before a case can proceed forward on a malpractice action. And then finally, for another type of non-binding dispute resolution, we have non-binding arbitration. The process is going to be similar to a binding arbitration, and this is an alternative to a court action, but where you still have parties in a dispute having their dispute heard by a third party. It could be a single arbitrator or a panel of three is typically how it's done. And there is a process in Florida for a court to refer a matter to non-binding arbitration. And in those circumstances, the arbitrator or arbitrators will hear the parties. Usually it's going to be arguments from the attorneys. They may hear from the parties. They may ask some questions, and then they're going to render a decision. And in a non-binding arbitration, that decision can be, in some fashion, you can appeal from it. It's not going to be necessarily binding on the parties, but there are some things to be aware of, at least with respect to the process in Florida. And when I'm licensed in Nevada. I'm not litigating in Nevada now. I haven't for a long time, but early in my career, I was involved in the non-binding arbitration in Nevada, where it's much more popular. Certain cases there at the time, at least when I was out there practicing, there were certain cases that almost instantly were referred over to a non-binding arbitration. Very early in the process, before the parties spend a lot of time and money on a case, and they would go through the non-binding arbitration. And folks would ask, I've heard this, well, if it's non-binding, what's the point? Why would somebody go through a non-binding arbitration? If you don't like the result, you're just going to say, okay, I don't like that, I'm going to go to court. Versus a mediation where, that process is non-binding, but all the parties are agreeing and signing a settlement agreement. In the non-binding arbitration, the parties are presenting their arguments and the arbitrator is making a decision, and then you can stick with the decision or not. And the short answer to that is that sometimes that arbitrator gives the parties, sometimes parties go to a mediation and they'll ask the mediator, what do you think? What do you think is the correct result, or who do you think is right, or what do you think we should do? And really, that's not the role of the mediator. The mediator is supposed to facilitate the parties coming to some type of negotiation or resolution over what their disputes or differences are and creating a solution for themselves. They self-craft a solution, you put that into a mediated settlement agreement. That mediated settlement agreement then becomes enforceable by the court and can even be adopted as part of a court order. In this non-binding arbitration, the third party makes a decision, but what my experience was that sometimes the arbitrator, like courts will tend to do sometimes if it's on a monetary issue, sometimes the arbitrator will split the baby and rule in favor of the one party on certain issues, the other party on certain issues, and maybe there's 5 claims and $100,000 in dispute, and the arbitrator kind of splits it down the line. Everybody feels like they get their day in court, they get to be heard, they get a decision, and they look at the decision and have to decide, all right, is it worth it to keep fighting, or am I satisfied with the result, even if the result's not perfect? And that can be often the case, that the result isn't perfect, we'd like to have done better, but it's not enough to continue to fight over. It brings the parties closer together. Now, in the process in Florida for the non-binding arbitration, and I'll walk through this, actually, I think it's on the next page. So I want to walk you through that process. Yeah, here it is. So it's under the Florida rules, and there's it's chapter 44 and then rule 1.800, and there's a couple other rules in Florida. If you pull up the rules of civil procedure for the attorneys, you'll find the rules on non-binding arbitrations. The process is quick. The court's going to refer a case to a non-binding arbitration. The parties go to the arbitration. They have to select an arbitrator within 15 days, or panel of arbitrators, and usually the court will tell you it's one or three. And then once the arbitration starts, you've finished the process within 30 days. So it's a quick process. Once the process is complete, the arbitrator has 10 days to issue an award, and it has to be a written award explaining the ruling of the arbitrator. And then this is similar to, if anybody's been in federal court and you've dealt with magistrates that'll enter an order, and then the judge finalizes the order if nobody challenges the magistrate's ruling. Not quite as formal, but very similar to that. In Florida, if nobody challenges the decision of the arbitrator and challenges it in a timely fashion, and you have 20 days to do so, at least last time I looked at the rule, then the award becomes binding on the parties as a judgment. And if you do want to challenge it, you can appeal for it. Trial de novo just means a trial with the arbitration process was without prejudice. Nobody, the court is not influenced by the decision of the arbitrator. So the court now can make a decision separate from the arbitration. If there's no appeal, then the court enters the judgment based on the arbitrator's award. But if there is an appeal, if you challenge it, and one party or the other, this is very similar to the offer of settlement, offer of judgment rules that we have for attorneys in Florida. If a party does 25% better than the arbitration, then they can potentially recover their attorney's fees and costs. So if I want to appeal that process, and I've gotten a judgment for $100,000 according to an award from the arbitrator, and I'm the plaintiff, and I say, okay, I want to go to court and I want to challenge that. And now I go to court, and the court rules in my favor, but only awards me $60,000. Well, I haven't, the award is more than 25% worse than what the arbitrator awarded, and that opens the door for the defendant now to make a fee claim, to try and claim attorney's fees, even if there's no attorney's fees provision in a contract or in a statute. Under that rule, you can potentially claim fees. So that's, and the time frames, I cited this case here in Florida for anybody that wants to look at the case or is in this position with a non-binding arbitration. This was a case, this Alexander v. Quail Point 2 Condo Association. There, the court held the parties to the arbitration deadlines strictly. One of the parties did not appeal within 20 days and tried to challenge it. And because the time had passed, the court said, look, you had 20 days. After 20 days, it becomes a judgment, and we're going to hold to that decision. All right, another process. Now we're going to talk about binding alternative dispute resolution, and we'll see arbitration again in a few minutes. But before we get there, expert determination. This is a relatively new process, at least as far as these being treated as arbitrations. I did find a case on it. We see expert determinations a lot, where we often see them as in valuation issues, like in real estate. You may have, if you have a lease, your lease renewal may be based on the opinion of a third party, an expert, either an appraiser or a real estate broker, who will tell the parties what the value per square foot should be for the lease when you go to renew the lease. We see this in purchase options a lot for contracts, where you have a right to purchase the property, but it's going to be based on the value of an appraisal. We'll see it sometimes for company buyouts, where the regular accounting firm of a company renders a decision on what the book value or fair market value of assets is, and the buyout of a particular person who decides to leave is based on some function of that value, maybe whatever percentage they own of the company, and you're relying on a third party expert to render a decision and make that decision binding on the party, so you avoid a dispute later where the parties are going to court fighting over what, for instance, what value is of a company or of an asset. The courts have faced these in different ways. Can you take an expert determination and make it binding in court? Well, some courts have enforced it as a contract. Some courts have enforced it. If you treat it as an arbitration, want it to be binding and cite the arbitration code, they might treat it as enforceable as an arbitration award. Hey, you decided that third party is going to make the decision, and this is how we're going to resolve the dispute. If you do not specify that it's binding on the parties, and then chances are it's going to be a contract provision that you're going to try to have to enforce. So there's a drafting tip for attorneys, and I'll flip over here on the next slide here. I got the issue at the bottom. Will courts treat these types of determinations as binding, like they do with arbitration opinions? And I found a couple cases on this. In one case, an agreement of the parties stated that an accounting firm was going to make a decision on the contract, but they were acting as experts and not as arbitrators. And in that case, the agreement was enforceable by the court as a matter of contract law, which sets you up for a pretty straightforward motion for summary judgment. If everybody has agreed that this party is going to make a determination, and that's in the contract, and the party makes the determination, you want to enforce that, then if you have to enforce it and the other side won't agree, you file your action and you file your motion for summary judgment based on the decision of the chosen expert agreed to by the parties. In a different context, we have this seed holdings case where again, it was accountants were tasked with making certain price revisions in an asset purchase agreement. And even though the term arbitration was not used, because the parties had all agreed that the accounting firm was going to make this decision, and this decision would be binding on the parties, the court treated it as such, and essentially treated it as an arbitration award, enforceable, and just reduced it to a judgment. And so what do we get out of this is that, my take on this is if you're going to use this process and you want it to be binding on the parties, you may want to refer to the Federal Arbitration Act or Florida law on arbitrations or whatever state you're in, or at least call the process an arbitration. The parties hereby agree that this decision, the value of the property's sale price, for instance, on a certain date or when the parties decide to split, is going to be based on a third party expert who will act as an arbitrator for that decision. That has a good chance, in my view, of being enforceable as an arbitration award. If you phrase it that way, at least more likely to be enforceable that way than if you don't have that. Of course, then the challenge there will be, and there's another case that I cited here, that maybe the arbitration process or procedure gets challenged in court. But that's a tough argument. I've done that a couple of times. It's very difficult to take an arbitration. Usually we don't even bother to challenge them. If somebody has an arbitration award entered against them, I've evaluated those several times. Only twice have I ever challenged them, and it was because there were specific grounds. And in both cases, it had to do with the contract. It had to do with, in one case, my party, there was multiple parties to a dispute, and my client simply didn't sign a contract where everybody was ordered to go arbitrate. So it created this cluster of a situation where you had 3 or 4 parties off in an arbitration. My client sitting on the sideline because they hadn't executed the same contract, waiting for the arbitration to play out. And then from that, then the parties on the arbitration would have to decide if they were going to bring my client into a lawsuit for any reason. It was just a lot of complication, really probably created by drafting at the time by parties on their own or folks who really didn't put a lot of thought in the dispute resolution process ahead of time. And then another time, I had a client had an arbitration award entered based on an arbitration provision in an agreement where the agreement was forged by my client. And we had an expert that said it was forged. When we went to court, challenged it. The arbitrators got no jurisdiction because the client never agreed to the arbitration because a forged signature is not binding on a party if you can show that it's forged. So this is just echoing the comments that I just made here, that if you label this expert determination in arbitration, it's likely to be enforceable. But again, be aware that that the process could be subject to challenge, especially I would say where you're most likely to see a challenge to this is, pardon me for that, switch back there. You're most likely to see a challenge is in a situation where it's one-sided. If somebody says, okay, we have a contract, this is the contract you're going to sign, let's say an employment agreement, for instance. We have all our employees sign an employment agreement, and it says when they, if they separate from the company, this is what they're entitled to, and it's all determined by, the accounting firm or a group who works exclusively for the company. That would be one context. Anytime it's parties on opposite sides of agreement, versus where I think it would be very useful to have provisions like that, where it would be easier, I think, for a court to enforce it, would be in a shareholder agreement. If all of the shareholders or the members, shareholders of a company, members of a limited liability company, all agree and sign an operating agreement that says, we agree that if there's a dispute over these certain issues, this person or this group is going to resolve that dispute, and they will be the arbiter of the dispute, and we want that decision to be final and binding. If all of the parties agree to that, and then later an issue comes up, I think it's going to be very hard to attack that process. That's just my hunch. I haven't actually gone through that particular challenge, but just knowing how hard it is to challenge arbitration agreements or arbitration awards generally, that would be my inclination. In order to make it more enforceable, you want to call it arbitration. So we talk about non-binding arbitration. We'll talk about binding arbitration. And of course, the one key distinction right away is that in a non-binding arbitration, there's some process where you can go forward. Usually that is associated with court action. So if you don't like what the arbitrator had to say, you can go back to court. In a binding arbitration, that's a complete alternative to going to court oftentimes, or sometimes the parties may end up. I have filed cases where you file the action to enforce the arbitration because there's an arbitration provision. So there could be a court action going on with the arbitration at the same time, but it's typically going to be an alternative to your action in court. It's usually based on the parties' agreement. Almost always it's a contract the parties have agreed to in advance. You may have agreed to arbitration provisions on your cable TV bill or with Verizon or your credit card company or your bank, not even be aware of it. Again, when I write contracts for clients, I deal a lot with folks in the medical community. I deal with a lot with folks in the technology community. We don't want to be going to court. We don't want our disputes to be public record. We're dealing with confidential information, banks, healthcare services, physician groups, anybody in medical technology. These are all areas where you're dealing with a lot of confidential information. You don't want this stuff in the public record, and arbitration is very effective to keep it out. The parties agree to an arbitration provision, and then the arbitrator, very much like a judge, renders a decision that's binding on the parties. You have witnesses, you'll have cross-examination, you have a formal hearing process. But what's good with arbitration that's different from going to court, and the courts have been more flexible recently since with the pandemic, but the arbitrators can be much more flexible with the rules as far as if all the parties want to do virtual hearings by remote video technology or do the final hearing that way. More than likely, depending on what system you're in, you're going to be able to do that. If you want to limit discovery, you're not going to do depositions, or you're going to limit the number of depositions, or you're going to do an initial document exchange. You can agree to that, and the process is going to be much more streamlined than if you go into litigation. But the arbitrator is still in a position to be in a neutral third party. The arbitrator doesn't typically talk to the parties individually, so there's no ex parte communications. All the communications are with, just like if you were in court, it would be the arbitrator and the parties all communicating together. And then again, the process when you get to arbitration is a little bit more, it's a little looser, a little bit more flexible, not quite as formal. Parties can typically represent themselves. If you think about going to court, even if you're, I have a company where I'm the only member and owner and employee. I have, say Joe's Plumbing, and I operate under Joe's Plumbing LLC, and I now have a lawsuit. I want to sue to collect a bill from a client, or I have been sued because I haven't, somebody's suing me and claiming I didn't do the services that I promised. Well, Joe's Plumbing LLC in court needs a lawyer to represent the company, because an individual who's not a lawyer can't represent another person, including an LLC or some other entity, even if they wholly own that entity. With some exceptions, small claims court you can, but in a regular court action, any company is going to have to be represented by an attorney. Mediations, arbitrations, not so. Typically in an arbitration, a company can send another representative, an executive, somebody who's maybe has an ownership interest or wholly owns the company to represent that party in the arbitration. It's private and entirely confidential, or can be deemed entirely confidential. And arbitrations I participated in, particularly with in medical, and in that context, under the AHLA procedures or other similar procedures, we agree from the outset everything's going to be confidential, and we don't want any records. We want everything being either returned or destroyed at the end of the process. And most people like it that way. So their disputes are not being made public. And you have that flexibility where it's not the same when you go to court. The process for arbitration typically starts, of course, with your agreement to arbitrate if a dispute arises. Later, if the dispute does arise, you invoke that agreement. You select your arbitrator or arbitrators. Sometimes that's done independently. Sometimes you pick a particular body. You may automatically have a contract. Again, it puts you into FINRA or AHLA or AAA or JAMS. There's a number of different organizations that provide dispute resolution services. But you don't have to pick those. If the parties have a reason for picking something else or picking certain arbitrators. Now, I am aware of at least one case where it was a construction industry and the contract called for arbitration, and the arbitration panel was made up of other contractors in that same industry. And I did see that arbitration get overturned by a court for being inherently unfair. It's the only case that I know of personally where a court came back and said, no, we're not going to let we're not going to let three plumbing contractors decide a dispute between a property owner and a plumbing contractor. We just don't think that's fair, especially when they've looked at 100 disputes over the past 3 years and always ruled in the plumbing contractor's favor. For the record, it wasn't a plumbing contractor, but it was a similar situation. So once we have we select the arbitrator, we have the hearing. There could be some discovery, but again, it's going to be much more limited. And then we have our award, and the enforcement of the award is done through a judgment in court. Just watching my time. I've got a few minutes because I want to touch on some of the advantages and disadvantages. Very limited grounds, as I mentioned earlier, to be able to overturn an award for arbitration. The most common one, and I've used, is this last one at the bottom of the list here, that there's no agreement to arbitrate. But note that you can waive that. If you show up and participate in an arbitration and don't raise the objection right away, you can potentially waive that argument. I put this fun fact here at the bottom. How do people go into court? How do they have these courts that are on TV? If anybody remembers Judge Wapner in the People's Court or Judge Judy, and those are actually arbitrations. My understanding is, at least from the ones I've seen, the parties agree to arbitrate, and they treat it like a court, but it is binding on the parties because the parties have agreed that whatever Judge Wapner or Judge Judy says is binding, and that's what we're going to stick to. There's two hybrid processes that are fairly new. It's really the same. It's a combination of mediation going into arbitration, or arbitration where the arbitrator steps away from the arbitration, becomes the mediator, tries to get the parties to resolve their case, and if it doesn't resolve, then steps back into the shoes as an arbitrator and gives the parties a decision. In the first process, just mediation arbitration, the parties will have a contractual provision that says we're going to mediate. We're going to pick a mediator, mediate with that person, and if the mediation is not successful, then we will have that person, since they're already familiar with everything, that person will step into the shoes as an arbitrator, hear the case, and make a decision. There's a lot of talk about this over the last, I've heard more about it in the last couple of years. There's some problems to be aware of. Fundamentally, what makes mediations work a lot of times is the party's knowledge that everything they say to a mediator is confidential. So we can be in a mediation and somebody says, Eric, I'm going to tell you something, but I don't want the other side to know. And it's my job, if I'm the mediator, to make sure I keep that information confidential. And I can't take it to the other room. I can't take it outside the mediation. And if somebody asks me about it later and wants to use that information in court, they can't do it. Somebody wants to bring up an issue, and there's some colorful cases in Florida. I've been involved in one of these several years ago where a client of mine was alleged to have taken mediation information and tried to use it to another party's disadvantage after the case, and they got in trouble for it. The mediation often works because of the confidentiality. So if you have confidentiality and the information you disclose in mediation is not, can't be used against you later, then how do you open up and disclose potentially confidential, private, and damaging information to a mediator who then can step into the shoes as an arbitrator and make a binding decision on you? I think that's a challenge that has to be overcome. I think either you're going to hinder the mediation process because it's not going to be as open as it otherwise would by having the same mediator potentially step into the shoes as your decision maker as an arbitrator, or potentially you have a problem where the arbitration could be challenged because the mediator relied not on what was presented, or pardon me, the arbitrator, in wearing the arbitrator hat, relied on information that was either not presented in connection with the arbitration hearing or was not admissible in connection with the arbitration hearing, but it was already in the mediator / arbitrator's head. I think that's going to be something that has to be worked through. Candidly, I'm not sure what I think of that. When I draft contract provisions right now for my clients, what I will often have is that there's a process that requires mediation, requires arbitration, but it's not with the same person. So you can do that. You can have the mediation arbitration, but not have it be the same person. I think the other style where you start with an arbitration, then maybe go into a mediation and then maybe back to an arbitration or not, could potentially be more useful for the parties because the arbitrator starts hearing the case and then tries, after hearing it a little bit more formal environment, then gets to sit down with the parties and try and help the parties craft their own solution. But on the other side, what some people will say is that during mediation, we all hear this. People will ask the mediator, "What do you think should happen? What would you do? How would you rule if you were hearing this?" And so the parties maybe get what they ask for. If they have a mediation, it's not successful, and ultimately have an arbitrator decide the case. So I have a couple more slides that I want to, a couple more than I get to hit today. So I'm going to just finish up my last 2 minutes here. Some distinctions between arbitration and litigation, and I think it's important for everybody to know more flexibility in the arbitration. The relaxed rules of evidence, but note that I have an asterisk there because if sometimes the strict rules of evidence can be an advantage to a party. If an arbitrator makes a decision based on hearsay and loosey-goosey documents and testimony that have no reliability because they would not be admissible in court, that could be a problem if your case is otherwise a tight case. Party self-representation, but again, that can be an advantage or a disadvantage because a lot of folks going into this process, if there's a lot on the line, you probably should be represented by an attorney. The costs, I put an asterisk here because while the costs of arbitration in the long run are going to be lower, with court, when you go to court, the state is paying the judges. You have to pay a filing fee, but the state's paying the court system and providing that, or the federal government's providing the court system, where arbitrations are private, so the parties have to. So the parties often get a shock when they find out that they've got to pony up $20,000 or $25,000 each as a deposit to push an arbitration along because they got to pay the arbitrator. And the other thing that people don't like about arbitration sometimes is if you get an arbitrator who goes off the rails, it's very tough to challenge that. You're just stuck with that decision oftentimes. There is an ability to challenge it, and that was in some of the materials I hit on earlier, but it's a tough process. And finally, one last thing that I want to mention as we close up here is what's been a problem sometimes is, what if you have an arbitration provision and the other side ignores it? They won't respond. You need to be able to address that in advance. You can always file a lawsuit and file a motion to compel the arbitration or mediation or whatever else you're doing. You can treat the arbitration provision as waived. Maybe you don't want to be in arbitration, but it's somebody else's contract. You'd rather just go to court, so it's been waived. Or you can have a contractual provision that says, hey, we agree to arbitrate, and if I give notice of arbitration, I pay my share of the deposit, you don't pay yours. That's going to be a default, and by not paying your share of the deposit, you waive your right to participate in the arbitration, such as by cross-examining witnesses and presenting evidence and so forth. So that's probably my biggest takeaway for the lawyers today is if you're going to use arbitration provisions, make sure you have a really tight mechanism to enforce it when the time comes. Otherwise, you end up just floundering around for 6 months trying to get the arbitration moved forward. And with that, I'm going to close out. Thank you and have a great day. Bye-bye.